Hi everyone, lovely to be here. As we said there, the session is on SAMD and AMD liability through a wider lens. I'm Jamie Gallagher. This is Brian McElligott, who's our head of AI, and we're both partners from Mason, Hayes & Curran, which is one of the largest law firms in Ireland. We're based in Dublin. We have over 600 staff, 120 partners. Our sector focuses, well, two of our main sector focuses are healthcare and tech. So Brian and I work with about a dozen or so other partners as part of a core group. And a lot of what we do is in the digital health space. And certainly Brian and I overlap a lot on SAMD and AAMD projects. I suppose in terms of designing the session, we have a huge amount of change going on in the sector. We've got, MDR, IVDR not perhaps fully bedded in yet. We have things like the AI Act. Going to speak a little bit about the Product Liability Directive and an AI Liability Directive that sort of comes in alongside the AI Act as well. Things like the European Health Data Space. I mean, it's sort of still a never-ending list, and there's talk of perfect storms that are still yet to come. I think we've had these really good sessions throughout the week that sort of zoom in on those individual topics. I think one thing that we come across working with clients is that there's so much change coming in, there are so many things to keep track of, and there are so many specialist areas that they need the digest on or the deep dive on. Keeping track of that bigger picture becomes very difficult, and sort of lining everything up and landing all of these new pieces of legislation and amendments and what to do about it is actually a sort of a larger challenge when you take a step back. So that's what we're trying to do with the session. We're trying to begin to arrange everything in one place and make it a little bit more digestible and a little bit more accessible. And that's what we mean when we talk about viewing it all through a wider lens. So just to maybe illustrate that, I mean, sometimes when you come to this sort of digital health space, I think certainly in my head sometimes conceptually it can all be a bit of a jumble. I mean, that is colourful, there's a lot of words there, but it's very hard to make sense of it. And I think that's how it can sort of appear in our minds, and we pull bits out as and when needed, and then we put them back in the jumble, and it's not particularly helpful. What we want to get to is something like this. Now, that is an ideal. I think there's still so many moving parts. That is the sort of conceptual framework that we'd like to have, where we can arrange everything in this more accessible way. We're lawyers, so we're putting our little subheadings very much in sort of legal practice areas. We try and sort of get out of that, but that's sort of the perspective we bring. We do try and arrange them around this concept of risk, though. I think that is a common touch point. And when we talk about liability through a wider lens, that wider interpretation of liability is, for us at least, legal risk. And that's, I think, where the common language can start to develop. So to get into it, we're going to work our way around that circuit. A few things before we get going. The framework is sort of customizable. We've focused on things that, we find ourselves looking at a lot for clients. There are other areas, reimbursement being one. Sometimes depending on the stage you're at with your business, it could be funding. Other times it might be competition. So you can add, take away, insert as and when needed, but these are the ones that we're going to cover today. We've tried to standardize each section, and this is again based on what we find clients tend to want. What are we talking about? Why is this relevant to me? So what do I need to do? And then we're going to be moving quickly. So we're just going to do high-level headlines on as many things as we can get to in the 20 minutes. But we have put in little sort of learn more slides at the end, which have links to some of the documents or guidance we're talking about. So we can share the slides afterwards, have a look at that, chat to us if there's anything that is particularly interesting to you. So to quickly get into product safety, and we're going to work our way around, we have a little dashboard on the left there so we can sort of track our progress. Product safety, I'm not going to dwell obviously on MDR, IVDR, the ever-evolving guidance. Everyone's very familiar with that in the room. I think the two headline points, just to draw out here, from my point of view at least, are the transition timelines. So what we're seeing is, earlier in the year, a lot of excitement around the extension of the timelines. Certainly a lot of devices that we look at, software devices, they would be in that class 1 being up-classified space. So we're into 2028. And the key message is, don't become complacent. We are still looking at, there are various strings attached, so you need to have your formal application in with the notified body by May 2024. You need to have an agreement executed by September. You need to have an MDR compliant QMS in place now. and all of the usual Article 120 requirements still apply. So no significant changes. You still need to have things like your post-market surveillance, vigilance, registration requirements looked after. There's sort of two experiences on that I'd share. One is sort of the nice side, and one is sort of the ugly side. The nice side is, I see our colleague from the notified body has just left, but this is another sort of pro-notified body group hug moment. I was attending a RAPS webinar, an Ireland networking group event. There was a senior person from the Irish notified body, NSAI there, actively encouraging stakeholders to get in touch, speaking to this very point, saying, our doors are open, please do come and speak to us. There was reference made to things like structured dialogues. This is one of the points in MDCG 2022-14. You know, it's not a consultancy service, but it is a way to get in contact, send an email, have a call, try and begin to bring some predictability and some, I suppose, a line of dialogue, open that up so that you know when you might be getting your application in, what is expected, when submission dates might be. That's the nice side, that I think it is very encouraging that notified bodies are engaging and reaching out and encouraging people so they can get their own sense of any sort of latent demand that's out there. I suppose the uglier side is I was recently advising on a transaction, which was an acquisition of a company that had a software medical device app. That was the core of the business. So we were advising the prospective buyer. So regulatory due diligence formed a large part of the deal. It was a class 1 device under MDD that was being upclassified. So the questions on the regulatory side became around, well, what are you doing to transition it onto the MDR? The answer that came back was, we've been advised separately that we don't have to do anything until 2028. So we're not worrying about it, and you don't have to worry about it. I can't get into the specifics because it was a recent thing that we were involved in, but suffice to say, that regulatory piece, everything else dropped away. That became the focal point of the whole deal as to what's going on. And the regulatory people in the company were coming on calls and accounting for why they'd adopted this approach. And we were talking all about the amendments and what they needed to do and if that was happening. And that can be a potential acquisition, can also be an investor, and also things around significant change. It's a long time in the software world, even from May 2021. So people talking about 2028, it's not particularly satisfactory from a commercial perspective if you're not really allowed to make any major overhauls or design upgrades to your device. So with that, that's product safety. Brian, I might hand over to you on AI, if that's okay.
Great. Thanks very much. So our first presenter covered a good bit of this, in fairness, in that first presentation. So maybe I could step back and give a little bit of context to this. I will be surprised if you're using AI as a safety component in a medical device, or it is the medical device itself, that you're not high risk. I mean, that's kind of the takeaway point. You're going to get caught by the regulation more than likely. One thing I would say is spare a thought for your colleagues in the technology sector. You guys are well set up for dealing with the regulatory burden that's coming down the path. Now, admittedly, it's more pain on top of the initial pain you have, but you're organizationally, you are set up to deal with this. You understand the process of, I want to launch a product. I need to, aim for my compliance by X date. Your colleagues in the technology sector who are also going to get hit with this regulation usually, spin up some minimum viable product, put it on the market, cross their fingers and iterate. Those guys now have to step up to your standard also. So maybe from an element of context, I think you guys are you're getting more pain, but it's a lot less pain than I think your colleagues in the technology sector. And also I think it's probably useful to note that in the first presentation, there is a grandfathering provision in there. So keep your eye on that because it notes products already on the market prior to entry into effect of the law, subject to substantial modifications. So keep your eye on that one. I think it will be an important strategic planning part of your business.
Thanks, Brian. So on actions, just super quick. Notified bodies, contact them, engage. I think that's really important. And that's the message just again and again, but you're still going to come across people that are saying, I don't have to worry about it until 2028, and everyone will have a small heart attack. And then also the AI Act. I mean, I'm not going to traverse that. We're talking about that in a lot of detail, but just engaging with the reality of what that's going to look like. Next up is product liability. I'm going to do my best not to spend too much time on this. This is one of these learn more things we can have a look at later on. This is something that I'm particularly interested in. I think it's something that, I mean, Brian mentioned how the medical device community excuse me, are sort of reasonably well equipped already when it comes to things like the AI Act. I think actually on the product liability side, you know, medical device software developers are pretty well equipped as well. The product liability directive, the existing framework, is from the 1980s. It's about 30, 40 years old now. You also have a new piece of legislation called the Collective Redress Directive, which I'll turn to later on. This is a sort of another, I suppose, liability perfect storm that's coming down the track for software developers and developers of medical device software specifically, I think. And you have, I suppose, not to get into too much detail, with product liability, you get into strict liability under the directive. There are also fault-based systems where claimants who are injured by devices or products have to prove that the manufacturer has done something wrong, and they've failed to take a step, or they've willfully done something that they shouldn't have done that has led to the defect, that has led to the damage. You also have contractual systems, which we're not really going to speak to. Ordinarily, you need a contractual connection or nexus where there's a contract between the manufacturer and the person that's injured. That doesn't often exist with a lot of devices or products, so it's less relevant, but it's another source of liability for damage. The big revisions coming down the track in this space are a revised product liability directive. So this is the strict liability system, and just to frame this for you, if you have a claimant who's injured by a product or a device, they need to prove 4 things, basically: that there is a product, that it is defective, and that it has caused a damage. And under the existing product liability regime, which is so old, a claimant who's been injured by a piece of software or a software device has a lot of difficulty crossing all 4, but especially those first 3 hurdles. So that means that, you know, when you look at the relationship between product safety and product liability, medical device software developers are fully, you know, at home with the concept of a piece of software being a product for safety purposes. When you look at the product liability landscape, it's described in some of the guidance as sort of the other side of the coin, but I think for software developers, it's almost like the dark side of the moon. It's just not something that you've ever had to think about, because software doesn't qualify as a product under the old framework. The big change, so that first step, you know, do you have a product, is actually, you know, a huge hurdle for a claimant to get over. The first massive change, and the key change here, is that software will be brought within scope of the product liability directive. So things like software medical devices will form sort of viable targets, if you will, for product liability claims. So that's got a huge impact, you know, on the wider tech sector, but especially for medical device software. When we look at a lot of the traditional product liability case law and litigation, a lot of it is healthcare products and pharmaceuticals and medical devices. Software medical devices will now be drawn into that. So it's something you really have to start thinking about. There are those other ingredients as well. I mean, the Commission proposal was pretty strong in terms of lowering the barriers that a claimant, those kind of things that they have to prove. So things around, you know, is your product, is it defective? How do you prove that? Defectiveness is defined as, you know, a product that falls below a level of safety that the public at large would be entitled to expect. So that's a very subjective test. You have criteria that courts can sort of consider when they're deciding whether or not something actually is defective. The new criteria under the revised proposal have all sorts, it's a bigger list, and it's specifically targeting things like software and things like AI. So it's talking about taking into consideration products, you know, read software that can continue to learn after it's deployed. Also talking about, you know, expressly talking about breach of safety requirements as something that could render a product defective. So think about the MDR there. And also things like product safety interventions, so things like recalls, withdrawals. That can be weighed in the balance as if that has happened. It indicates that perhaps the product is defective. So that is making it easier for a claimant to sort of jump that hurdle. And that's in circumstances where these products are very technologically complex and sophisticated, and it is very difficult at the moment for a claimant to point to exactly how a piece of software has broken or malfunctioned, and even more so when we're talking about an AI system, where it's very, very, the opacity and the black box element. That onus is on the claimant, but this legislation is designed to make it easier for the claimant to prove their case. It goes as far as to talk about these rebuttable presumptions, which is very radical, where if you're a manufacturer of a device, you're safe until you're proven defective. It's for the person making the claim to prove their case. In the original proposal, there was talk of, especially with technologically complex products, and things like innovative medical devices and AI systems are called out in the recitals to the proposal, where you would have this, the onus would shift, the tables would be turned, and if a claimant could satisfy some threshold criteria, which are quite low, it's talking about things like there being a reasonable likelihood that the defect caused the damage, but that you as manufacturer would be presumed to be defective until you could prove, you would have to argue back and re-establish the safety of your product. That's on the defectiveness hurdle. So we've got product, okay, software product, defectiveness. There are a lot more ways to be a defective software medical device. Also, there was talk of rebuttable presumptions of causation. So how is the defect actually causing the damage? If the product is so complex that we don't know, you get this, you could benefit from this other rebuttable presumption. And then we're getting into things around excessive difficulties. If a claimant would have excessive difficulties in proving these things, they might have access to these presumptions too. Now, those presumptions have been sort of diluted when we get into sort of the Parliament and the Council inputs. They've been streamlined, so it mightn't be a full rebuttable presumption, but the thresholds are still a lot lower. And the message is still, there is a much clearer path for somebody who's injured or says they've been injured by a software medical device to make that claim and make it successfully. And that's once these revisions come in and are transposed at member state level. There's plenty more you could talk about the Product Liability Directive, I won't. AI Liability Directive, just to quickly mention the relationship there. AI systems and software, AI systems are dealt with under the Product Liability Directive, but that speaks to this strict liability system where all you have to do is show that the device is defective. You also have alongside that the fault-based systems, the negligence systems. The AI Liability Directive is there to sort of fill that gap as well and make similar accommodations for claimants who are taking claims and they want to establish or need to establish that the developer of the AI system has been negligent in some way. So similarly dealing with issues around complexity and giving them more opportunity to make their case in an easier way. Access to evidence is a big one there. They could apply for things like the logging system records of an AI system if they could, pre-making their claim. So they would be a potential claimant. This would be in the context of a contemplated claim, and they could get that information from a manufacturer in order to assess it and see if a claim was even there. So that's just an example. I've mentioned, in terms of next steps, I mean, yeah, it's really just getting to grips with product liability alongside product safety. To make a quick connection back, I mean, this is all dealt, there's a connection to the MDR in this, where Article 1016 in manufacturers talks about sufficient financial coverage for product liability cases. So you need to factor that in if you have we've done small justifications for tech files that talk about, if notified bodies ask for them, how do you assess that liability? I think coming into effect of this type of legislation radically changes that calculation. If you're a software medical device, there are a lot more potential claims out there. And then things like rebuttable presumptions, they might not be full rebuttable presumptions anymore, but thinking about how would you argue back, if you had a claimant who had a lot of tools in their arsenal from a procedural point of view to make their case and take down information from you and make out a claim. And then just to very briefly mention the Collective Redress Directive. This is sort of a perfect storm point. Collective Redress Directive is already in place, hasn't been transposed by most member states. I think the Commission has started infringement proceedings at the start of this year against 24 member states. What it'll do is member states will have to appoint qualified entities who are going to be consumer protection regulators, maybe consumer representative organizations. They'll be able to basically take group claims. And I think in the context of software, that's pretty important because you might have groups of litigants who wouldn't be too interested in going to a lawyer and spending the money on their own. But if enough complaints or if there's a piece of software that's very popular, it might be something that a qualified entity under the Collective Redress Directive would bring an action on. and they would be then availing on behalf of a large group of a lot of these new, provisions and tests. So there is a potential groundswell, and then we think this liability piece of legislation will be adopted perhaps this year. Product liability directive would have a transposition timeline of 12 months, AI liability directive of 2 years. That was in the Commission proposals. So it's sort of sitting there waiting to happen. I think it's a little bit of a blind spot, that liability side, to go with the safety side for a lot of software developers. And I think you've got the next
sure.
data privacy.
Thanks very much. So continuing with the theme of what's new in the space, I've chosen to have a quick look at the themes around generative AI and large language models, because this is a lot of the work I'm doing at the moment. And to kind of give it some context here, when I say large language model here, ChatGPT, there's many variations, but we'll just use ChatGPT because people know it the best. A lot of what's being done right now is people or businesses installing it into their customer interaction tools. Lots of people are doing it. I expect as many of you doing it as well. But I do know also that, let's say from giving the first advice on this around January of this year, that same customer has now escalated up to about 10 different variations of using this tool. And what I want to maybe give you some context here is consider the scenario where you're using this for many other different options, because it is incredibly powerful. You can use it in supply chain optimization. You can do it in invention mining. It is very useful, and the models can be tuned for very different reasons and purposes. So it may not be long before some of you might be seeing this kind of more deeply embedded in your organizations. On the privacy front, everything here was very well publicized in March of this year when the Italian Data Protection Commissioner suspended use of ChatGPT in Italy. It was about 30-40-day suspension, and issued a number of corrective actions, and they're listed there at the bottom of the slide. And they're related to essentially the launch of the technology without really much foresight or oversight from many perspectives, to be quite frank. Privacy being one of them, and just really basic things like there's no legal basis underpinning the processing, or there was no information provided to data subjects about the processing or their rights. This then set off a chain reaction across the EU and indeed across the world, where there's many different supervisory authorities and data protection commissioners holding ChatGPT over the coals. And then you'll see the latest development is that Google Bard, which had refrained from launching in the EU, is now subject to, I won't say an investigation, but a discussion, a technical discussion with the Irish Data Protection Commissioner. There's a back and forth, and that has resulted in its delayed launch in the EU. Internally, when you are onboarding this technology, I suppose my feedback is dealing with these organizations, generally their processing agreements are not that bad. Now, I'm not a privacy expert, but the people I work with, the feedback I'm getting is that it's not that bad. It's more for organizations to understand the processing that's taking place and the risks associated with it, and to assume those risks into their organizations and to adequately deal with them. And a lot of that will come with either conducting data protection impact assessments and putting in place strict guardrails for how you use the technology. We ourselves have just launched a pilot for the use of the technology in our own firm, with a view to maybe in a few months looking at onboarding some of the more niche legal technologies in this space. But again, we will only and can only do this subject to strict guardrails. They're not necessarily rocket science. It's very simple stuff. Don't put your client information into the machine. Don't put personal data into the machine. But that's the sort of space these machines are operating in from a privacy perspective. As Jamie said, we'll be given around the slides afterwards, and all of these information and guidance will be there for you. You can see by the number of links that there are many different authorities getting very interested in this. And some of these are really good information guidance on the use of this technology. Next one up is looking at this from the perspective of intellectual property. And generally, you're talking about copyright law here. In more advanced uses, we may be talking about patent law, and of course there's the AI Act. I have a list of some uses there where, as I said, I think, chatbots and personalized customer interactions are here, and I would say many organizations are doing this now. It's not in their plans. They are doing it and have been doing it for quite some time. The code generation piece is there already, so people are already using this technology to help them code within their organizations. There's also some highly publicized litigation around that space. But what I want you to keep in mind is that it won't stop there. It will escalate, and it will go right through organizations to things like product design, MLOps automation, systems optimization, possibly dealing with risk in your organizations and dealing with risks when it comes to dealing with your products. So bear in mind that a lot of these things I'm talking about right now are probably on your horizon. Generally speaking, when you're dealing with these large language models, you have an option. You can either go and license one, which is a finished product, or you can go and get the more basic model and tune it on your own database, which is the space everybody really wants to get to because you get highly personalized output. The example I can give you there is a client of ours who tuned a model on its website information. It's a fairly complex technical manufacturer and has an awful lot of information. So essentially what it's doing is turning its FAQs into a conversational type interaction, where as a customer you can just ask the bot a question and get quite a sophisticated answer. But what's it churning? It's churning just the information, churning the information that's coming up through the system. From your own perspectives, you need to look at diligence, I guess, on what's coming in the door, and also what's coming out of the machine, because there's well-publicized issues with that. And quickly then, just to come on to my last piece here on contractual liability, I want to go straight to the actions here. When you are dealing with these organizations, expect that you are going to be told what terms to take. I have it on good authority that the likes of OpenAI won't even speak to you about their terms and conditions unless you're spending more than €100,000 a year with them. And even at that basis, you'll get to have a look at a few pieces of the contract only. The key pieces from your perspective to look at would be the liability for what's coming in and out of the machine. But don't quite believe the hype just yet. Some of it is true, most of it is not true. The machines are not as bad as you think they are, and they are generally usable within your organization, subject to guardrails and subject to doing things sensibly. And we've got a quick final one.
Yeah, I'll just say 2 sentences on consumer protection very quickly. MDR Article 7 is there. It gives, it's quite comprehensive, but it's quite broad. The experience we've had is that marketing teams get very, very creative as to how they let the world know about the device or the software. There's always different channels and ways they can do that. There's not a lot of detail underpinning how to apply Article 7 in terms of what is and is not misleading. You can look to EU consumer protection legislation for that, so things like the Unfair Commercial Practices Directive, things around comparative advertising, some legislation there. And then a really good piece of guidance is things around substantiation and stuff. There's a lot of national fragmentation there as well. Just keep an eye on what's going on in the different markets. Training your marketing team is really important, and building up a threshold criteria for when they might want to come to you and run an idea past you. That commission notice is really useful in terms of giving a rundown of the sort of the tests and the terms. What is a marketing communication? Things around transactional decisions and what is and isn't truthful with reference to consumer protection legislation can often be a really good fallback when you're trying to sort of interpret and build justifications linking back to MDR Article 7. So just something to be aware of outside of the strict medical device space. And thank you, everyone.
Thank you very much.